So thanks for having me here. So I'm Visa Kurki. I think Kurki is Sokurk in Estonian. I think that's the same thing. Is it? I'm not sure what Visa would be in Estonian. So I've recently started as associate professor of jurisprudence. So jurisprudence means basically legal theory or legal philosophy. So I started in the beginning of this year here at the University of Helsinki. And I also just joined the Young Academy here in Finland this fall, so it's a pleasure to be here at this stage. So I'm just going to give a very sort of a general introduction to what I've been working on. This is not the only thing I've been working on, but I thought it might be useful to just explain what on earth sort of legal theory is all about. And this is something that I usually show my students to understand, like the stuff that we do in legal theory or jurisprudence or legal philosophy. So first of all, the stuff I mainly work in is so-called analytic or sometimes called clarificatory jurisprudence. So in this kind of jurisprudence, we're mainly interested in sort of clarifying legal concepts and trying to make concepts better, so to say, more understandable, more rigorous, more logical maybe, or something like that. And here you sometimes make a distinction between general and particular jurisprudence. And general jurisprudence is concerned with these very general questions, such as what is law in general? Can there be evil laws? So general jurisprudence deals with that kind of stuff. I guess the classical question is, were Nazi laws real law at all? Or were Nazi laws maybe it's law that, you know, some kind of pseudo law that didn't really have any kind of validity? Then we have a particular jurisprudence, which is where I mainly work at, and this addresses questions such as, you know, what does it mean to have a right? What are rights? What does it mean to own something? What is public power, the kind of power that authorities have, for instance? This is where I place my research mainly as well. Then there's something called normative jurisprudence, which mainly looks at how the law should look like. What would good law look like? As I say here, it evaluates law. So there's a question such as, you know, when is a trial just, or can affirmative action? So the idea would treat some groups better. For instance, we give extra points to I don't know, men if they apply to become teachers or something because there's a lack of men in teachers. So can that be justified or not? And here you can sometimes you distinguish between internal and external critique. So internal means that we sort of look at the values of the law. We look at the values of the Finnish law and we say that, well, you're not actually following your own values in a way. Whereas external critique would be more like, well, no, I mean, you're following the wrong values. You should be following different values. And then there's something called the critical legal theory, which is mostly interested in exposing power structures within law. So there's issues such as, you know, do perhaps legal norms reflect some kind of a male bias? So is there like an underlying idea that, you know, they somehow, like, let's say, criminal law is based on some kind of a idea of a rational male person or something like that? That would maybe be like critical legal theory. So just as a general introduction to this field. So what have I been working on then? I guess this is not working. So back 10 years ago, I was finishing my master's thesis. I was interested in animal rights and animal legal personhood. By the way, I also checked what legal personhood is in Estonia, and I think it's isik, or yeah. If you're a person, you're an isik. And I was very interested in legal status of animals, and then I encountered this idea that, so this is working now, great, thank you, that even though we protect animals by the law, so we have animal protection laws, but most lawyers would say that, well, regardless, we haven't given animals any rights because they're not legal persons. This is what you very often encounter. So we protect them, but they don't have rights. And then you see these kinds of texts. This is from an American lawyer, Stephen Weiss. Only legal persons count in courtrooms or can be legally seen, for only they exist in law for their own benefits. Legal personhood is the capacity to possess at least one legal right. Accordingly, one who possesses at least one legal right is a legal person. But then 10 years ago, when I was reading this stuff, I sort of took it at face value, I took it for granted, but I sort of started having this nagging feeling when finishing my master's thesis that what exactly is missing? Like, why can't we say that animals already hold rights? Because, for instance, if we talk about children's rights, it looks very similar. And of course, children have much stronger rights, like much more, they encompass many more things, they're much more strictly enforced and so on. But regardless, if we say that child has the right not to be beaten, for instance, if animals if you're not allowed to beat animals, why can't we say that the animal doesn't have a right not to be beaten, for instance? This is a conceptual question. Okay, this is not about how the law should look like. It's a conceptual question. So then I wrote a PhD dissertation on the notion of legal personhood in general. So not just animals. I got more interested in the topic in general, and basically my conclusion was that actually nothing is missing, that we can actually already say that animals hold some very limited legal rights. But they're still not legal persons in the full sense of the word, because legal personhood is what I call a cluster property. So it means that there's various elements that need to come together in order for you to be a legal person. And I don't know if this makes any sense for non-jurists here, but I would say that even though animals don't have the capacity for private law rights or duties, so animals can enter into contracts, they can own property and that kind of stuff, we can still say that under animal welfare law they hold some very limited rights. And a large part of the book is something that I call the orthodox view of legal personhood. So what is the orthodox view? Well, I'll get into that in a second, but I'll just say that 10 years ago, when I got interested in this topic, this was a very, very fringe topic, okay? Like, professors were telling me, like, right out that don't work on this. But I decided to do it regardless. And then you can see, for instance, in 2016, you suddenly have, I don't remember which newspaper this is from, some British newspaper. 2016, you suddenly have these like big newspapers writing about legal personhood and animal rights. And so it suddenly, like when I started working on it, it suddenly became a sort of big topic. This is from the New York Times, the thing on the right. Simultaneously, it's not just about animals anymore, as was mentioned in the introduction. The Whanganui River in New Zealand is now considered a legal person. This means basically that I'm not convinced that the river really is a legal person. I'm convinced that there is a kind of or the way I understand it is that you can think of it in terms of like a foundation that's set up to protect the river. But I'm sort of in the minority here. I think most people think the river really is a legal person. Anyway, the idea is this is like a new way of protecting nature. That's how I would understand it in the case of the river. And scholars are more and more talking about robots' legal personality as well. Though I should say here that the way sort of legal scholars talk about it is a bit different than how it's discussed in, I don't know, sci-fi movies, because normally what legal scholars are interested in is like, okay, so could a bank set up an AI that could do trades, you know, sort of independently from the banks in the marketplace? It's not as much about the kind of stuff that like in the movie AI. So, you know, what if we had robots that are completely sentient and conscious and so on? But there is that kind of stuff as well. So anyway, what is the orthodox view that I mentioned? So the orthodox view is this idea that there's a very strict division between persons and things, or subjects or objects, and there's a strict dividing line here in the middle. Okay, so you can only be one or the other. And you have this sort of very traditionally, so you have human beings here, then you have organizations, you have corporations. Organizations meaning, for instance, I guess the Finnish Academy of Sciences and Letters is probably, I assume, a legal person. Whereas then things or objects would include mobile phones and animals that I already mentioned. Bananas would be things. Traditionally also human slaves have been understood as things. And according to this traditional view, they would have no rights at all. And so this is what I usually call the orthodox inventory of the universe. So according to this way of sort of bookkeeping, according to this traditional idea of law, you have only two categories in the entire universe. You have persons, which are either natural persons or artificial persons. So natural persons means human beings who have been born, and artificial persons, which is, corporations in the broad sense of the term, so also including the state and so on. And everything else is things, and that's it. There's nothing else. Then you often, or at least sometimes, because lawyers like Latin that they don't understand, so there's a summa divisio. This means that this is everything, it's the sum of the universe in a way. And tertium non datur means that there is no third, so there is no third category. This is how it's traditionally been understood. But then here comes Kurki, who presents a new theory of legal personhood. I'm not sure I want to go through all of this, but the basic idea is that in order for something to be a legal person, it needs to be either an agent or what I call a passive right holder. So for instance, babies are not really agents in any real sense. And I think animals could fit into this category as well. That has been given a sufficient number of something that I call incidents of legal personhood. And what I mean by incidents, you can basically think of it as rights and or duties. So if you here compare a baby to a cat, if we think of the current law of at least Finnish law, I assume this is true for Estonia as well. So the difference between their legal status, so the baby is a legal person and the cat is not. So the difference is not just that the baby can hold rights and the cat cannot. Rather, there's a bunch of different things that how the legal status is different from each other. So the baby is not property, the cat is property. The baby can own property, even though the baby can't dispose of it himself or herself, whereas the cat cannot own property. If you harm the cat, you don't need to pay compensation to the cat, but rather the cat's owner, whereas if you harm the baby, you need to pay compensation to the baby. The baby has legal standing, meaning that you can have lawsuits in the baby's name, but not in the cat's name. I can't sue anyone in the name of a cat, for instance. It would be thrown out of the court. And so I'm not going to go through all of this. And this is what I call passive incidents. Then there's something called active incidents, which normally presuppose that you need to be an adult or at least a sufficiently developed in some regards, so that you can be held legally responsible and so that you can enter into contracts on your own. You can decide to enter into a contract yourself. You can sign a contract, for instance. Babies can't do that, even though contracts can be entered on their behalf. Okay? So this is sort of how I've then come to understand the sort of inventory of the universe. So you have persons here, you have property here, but then you actually have a bunch of stuff that's neither. And then you can actually be a little bit of both. So I think animals used to be here, now they moved a little bit this way. Okay, we started protecting them a little bit more. And we can already say that they hold some limited rights, but they're also property. You can still own them and buy and sell them and so on. And then finally, I didn't really get into the details of these different legal personhood arrangements, but I thought it's useful to think of why we would want to give legal personhood to some entity. And I think this is a very basic distinction between intrinsic and instrumental reasons for giving legal personhood to something. So if we think of the classical categories, we human beings are legal persons probably for intrinsic reasons, meaning that we are legal persons because it's a recognition of our status. I mean, taking legal personhood away from someone and sort of turning them into a slave probably would be an affront to their intrinsic value, to their value as human beings, for instance. But then we talk about corporations, they would probably fall here on the instrumental side. So we have corporations as legal persons because it leads into some useful societal consequences. It has some useful instrumental consequences. But then the question is, what about these new cases? I'm pretty sure that treating animals as legal persons would not really serve any instrumental purposes. It would have to be motivated by concern for their well-being, their rights, their moral rights, or something like that. With nature, I'm not so sure. I think with nature, like the Wanganui River, you can approach it from an intrinsic point of view. You can say that, well, we want to recognize the value that the nature has in itself, but we can also think of it as instrumentally that, well, this is just a new way of protecting nature, and that's it. You know, we want to preserve this river for future human generations. So that's more like an instrumental way of looking at it. And then with AI, I think I already discussed this, but if you think of AI legal personhood in terms of the intrinsic point of view, then there's more like the movie Artificial Intelligence, you know, like this AI is sentient and conscious being and we want to protect it. Whereas with the instrumental point of view would be more like, well, it would maybe lead to some good societal consequences if we held AIs responsible for, I don't know, like self-driving cars or something like that. Right, I think that's all. Yeah, kiitos. Aitäh.